Yeah. Good afternoon. My name is Jason Chavez, and I'm the chair of the Committee of the Whole. I'm going to call to order our regular committee meeting for Tuesday, February 11th. Before we begin the meeting, I want to offer a friendly reminder to all members, staff, and the public that these meetings are broadcast live to enable greater public participation. These broadcasts include real-time captioning as a further method to increase the accessibility of our proceedings to the community. Therefore, all speakers need to be mindful of the rate of their speech so that our captioners can fully capture and transcribe all comments for the broadcast. We ask all speakers to moderate the speed and clarity of their comments. At this time, I'll ask the clerk to call the roll to verify the presence of a quorum.
Councilmember Payne.
Present.
Wansley is absent. Rainville.
Present.
Vita.
Present.
Ellison.
Here.
Osman is absent. Cashman.
Present.
Jenkins is absent. Chiktai.
Present.
Koski.
Present.
Palmisano.
Present.
Vice Chair Chowdhury.
Present.
Chair Chavez.
Present.
There are 10 members present.
Let the record reflect that we have a quorum. The first item on our agenda today is an honorary resolution recognizing attorney Eric Nielsen. I'll invite the author and guests for their presentation right up here, so please work your way up.
If those that want to read this proclamation want to come up front, and if the guests that are here for Eric Nielsen would also come up front, we'll get started right away. All right. There's a lot of people up here for you, Eric, and we know it's because you're not really good at being the center of attention. That's never really been your thing. To honor all of your work. So I'll start by inviting my colleagues to help read this resolution, and then we'll have some comments from city attorney and former city attorneys, and then leave it to you. All right. Here, I'll just start with the first two. Honoring Eric Nielsen for his service and dedication to the city of Minneapolis. Whereas Eric Nielsen, having earned his law degree from the University of Minnesota, joined the Minneapolis City Attorney's Office on September 10th of 2001, thereby launching his career as a municipal lawyer. And whereas Mr. Nielsen has had a successful tenure spanning 24 years, during which time he served as Mayor Sharon Sales Belton, R.T. Ryback, Betsy Hodges, and Jacob Fry, and city attorneys Jeff Heffernan, Susan Siegel, Jim Rauter, Peter Ginder, and Kristen Anderson, and he will go on to be the city attorney of and for the city of Minnetonka. And
whereas Mr. Nielsen has held a number of progressively responsible positions in the city attorney's office during his career, beginning as an assistant city attorney and in 2016 being promoted to the appointed position of chief deputy for the civil division of the city attorney's office, where in addition to his own work, he assumed responsibility for directing and mentoring the entire team of attorneys serving as civil legal counselors and advisors to the city's enterprise, including its elected officials and appointed executives, boards, and commissions in all operating departments. And
whereas Mr. Nielsen himself led the office of city attorney when Mayor Fry appointed him interim city attorney in 2019 to fill the temporary vacancy when city attorney Susan Siegel left the post to accept the governor's appointment to the Minnesota Court of Appeals, and he provided steady stewardship of the city attorney's office during that transition period. And
whereas Mr. Nielsen
made many contributions to improving the city of Minneapolis during his tenure, the highlights of which include, but are not limited to, leading efforts that resulted in major improvements to the city's housing maintenance and building codes to address landlord and tenant issues, including a pilot project to change the city's enforcement of rental housing codes from a criminal prosecution effort to a civil prosecution approach and focusing on maintaining tenant occupancy while achieving compliance, an effort that resulted in permanent amendment to the city's compliance enforcement option that was codified by City Council and resulted in the city's adoption of the administrative citation ordinance approach to enforcement.
Helping to successfully shepherd state legislation granting local authority for the passage of a park dedication ordinance done in close collaboration with the Minneapolis Park and Recreation District Board of Commissioners and its attorney, resulting in the collection of more than $30 million to support neighborhood and community park improvements and amenities, taking the lead in 2008 to draft the ordinance which established the city's Downtown Improvement District, DID, at the behest of Mayor R.T. Ryback, serving for the bulk of his career with the city of Minneapolis as the city's land use and zoning attorney, collaborating with the Community Planning and Economic Development Department on numerous ordinances, policies, development, proposals, and comprehensive plans, and which also involved defending the city's priorities, policies, and positions in court and devising and advocating for changes in laws to benefit the city's goals and objectives, and
twice my size. Whereas Mr. Nilsson has exemplified all of the values of the city attorney's office, the legal profession, and the best ideals of public service, including a commitment to the highest ethical standards and excellence in providing legal representation and advice, justly earning him the respect of all who have had the privilege of working with him and those whom he has served, and bring it all the way down to Ellison.
Here, I'll hold it for you.
where are we at?
Served.
Whereas, throughout his tenure, Mr. Nilsson helped shape and mentor a talented and diverse team of attorneys, playing a critical role in forging an incredible public law firm and ensuring the future quality of the city attorney's office following his departure. And whereas Mr. Nilsson will be deeply missed by the mayor and city council and the city's selected and appointed officials, department heads, staff, and most especially his colleagues in the city attorney's office and his friends from across the entire enterprise.
Now, therefore, be it resolved that the mayor and city council do hereby commend and offer their most sincere gratitude and appreciation to Eric Nilsson for his exemplary service and extraordinary dedication to the city of Minneapolis, and extend him and to his family their best wishes and happiness in all future endeavors.
So, Eric, it took a team to put that together, and it's very incomplete. You know, you've been our city attorney during periods of my tenure, and we all know of your capabilities. One of my favorite memories, then I'll pass it off to others who have even more history with you, was I've never felt so satisfied and honored than when I have been in a room dealing with difficult zoning decisions with yourself and Jason Wittenberg, and I just loved the team that you both were. I felt like I really had all of the facts in the room with me when I was consulting staff and you were part of it. You're not afraid to say, no, that's not going to work. I appreciate that. That sometimes takes guts. And importantly, you were the kind of person that would tell us how we could do it the right way. So I'm going to let some of the city attorneys speak. I'll start with our current city attorney.
So I'm going to try to not get emotional. I've only cried 2 times in this job, and the second was when Eric told me that he was leaving us. I think that the display of people across the office up here shows how beloved you are, Eric. Everybody knows you're a great lawyer. Everybody knows that. But I think what everybody also knows is that you are such a good human.
You do what's right, even when it's hard. You are the voice of this is the way that things should be done, and you have the courage to say those things when it's necessary. And, you have never compromised your values in this role, and I think that's just something to be so, so proud of, and we're going to just miss you so much.
Is Peter up here? Does Peter want to run from the back? I'll give it to anybody else that wants to raise their hand for a minute. Yeah, please.
Eric, thank you for your service here. I think about often why somebody like me shows up to this role, right? And you're led with your principles and your values. And often principles and values don't want to be in the weeds. But anybody who worked in city government knows that if you want to execute on them in a meaningful way for the public, for people, you have to be in the weeds. And in my time here, you've been somebody who has been so thoroughly in the weeds while still understanding what the whole purpose of the enterprise is for, which is to deliver on behalf of people in Minneapolis. And I think that you've taken that service, that responsibility to others, the ways in which you represent others, your team, the broader public, really seriously. And so you're going to be missed. I hope your future employers knows just how good of a bargain they're getting with somebody as bright and as principled and as in the weeds as you are. So thank you.
Thank you. Thank you, Eric. I'm going to miss you. I know I sent a text right away when I got the message because I was so sad. I remember when I first got down here, the resolution says you mentored a lot of attorneys, but you also mentored one Ward 4 council member too on a lot of things. So I thank you so much for your service and everything you've done for me. You pretty much know every single thing about Ward 4, like every piece of land, how to use it, how not to use it. And that's really good for somebody like me who wakes up with ideas. Lene kind of stole my thunder with the saying no thing. You know how to say no just as well as I do, and I like it. It's kind of like a no competition when you and I are meeting. So thank you so much for always pushing back on the right things and really not pushing back, but really just showing me how to look at things in a different way, but also accomplish what I'm trying to accomplish. You're masterful at that. Like I come in thinking it should be something, and you're like, it could be that, but this is how we're going to get there, and the timeline of how we're going to get there. I'll also say I remember the first meeting with you. I thought, wow, he's really tall. And then you told me you had triplets, and I said, are they really that tall? There's going to be 4 of really tall people. So thank you so much for your humor, for sharing personal stories, just taking the time to get to know me and people in my office. We really do appreciate you. Thank you.
I've had the privilege of knowing Eric for the 24 years since he started in the city attorney's office, and when he first went into the zoning and land use area, which became obviously his strength and the strength for not only our office but to the benefit of the city. And Eric has always been someone who's made sure that he's able to get along with everybody that he works with, whether it's his coworkers in the city attorney's office, whether it's the department heads that he deals with, or the elected officials, where he's always given his best effort to give the best advice that he can on often complex and difficult issues. And as a resident of the city of Minneapolis for 50-some years now, I always hate to see really outstanding public servants leave the city, especially those that I've had a chance to work with. But I also really am happy for Eric to move on to the next step in his career and really benefit the city and the citizens of Minnetonka.
All right, did anybody else want to speak before I hand this over to Eric himself? Oh, go ahead, Councilmember Jenkins.
Thank you. Wow, Eric, I guess I can echo all of those comments that everyone has said thus far, but, if I'm not mistaken, I think you were the acting city attorney during the global pandemic and the racial uprising. And it was an incredibly challenging time for the city of Minneapolis. And you guided us through it with grace, dignity, and aplomb. And I just thank you so much for your service to this city. Yeah.
Councilmember Rainville.
Thank you. I appreciate you helping me out with that Van Buren land miss. And I know you thought I was crazy, but I have to admit, along with Councilmember Vita and Palmisano, you had a very polite way of saying no to me many, many times. Thank you.
Oh, gosh. Thank you. I'm overwhelmed, and any thoughts I might have had have left my head. But I can just say it's really good to see all of us kind of together in this moment. I really think that's the way we can hopefully operate more in the future. And as a city resident, and as somebody who will stay a city resident, that's what I would want to see as well. I'm really excited for my new opportunity, but I have been sort of a crazy cocktail of emotions. I've told people. A very wise person once told me, Casey Carl, that when you leave a place that you've been for a very long time, you go through somewhat of a grieving process, and there's some truth to that. I've kind of been feeling that way. Now it's becoming real, and I'm starting to get very excited. But it has been a grieving process. As a young person coming out of grad school, in this case, I didn't think there would be any. I was maybe somewhat cynical. I didn't think there was any possibility of doing meaningful work. Everybody always says they'd like to do meaningful work or something meaningful in their life, and I didn't think there was any possibility. I was hoping to get enough to pay the rent, pay a student loan bill, and maybe go out with my friends on the weekends, and that was good for me. And I had the great fortune of both being a law clerk in the civil division of the city attorney's office for 2 years in law school, and then getting hired after a judicial clerkship. And it has been the most rewarding experience of my life. It's the only career I've known, and it's been because the work is meaningful. It's for a city I love, and when you do meaningful work, and especially in working with CPED, you do work that is made manifest. You can see it when you're going about the various neighborhoods of the city. You can see something you had a small piece in advising on or working on, and that's incredibly gratifying. I'm also emotional because life and living happens when you're somewhere for a long time. And in my case, while I was with the city, living in the city, I met my wonderful wife, Melissa, who I love dearly. We had triplets, as has been mentioned. Have. Very much still have. Yeah. Thank you. Oh, I still remember I was on paternity leave, and actually we had them, and it was shortly after the council adopted the first parental paid leave policy, and that was in 2015. Susan Siegel, the city attorney, called me up to offer me the deputy position, and I had been on parental leave. Melissa had gone back to work. We kind of organized it so we each took our own time. And I was so completely delirious that she could have asked me anything and I would have said yes at the time. So it's emotional when you think about all of these factors of the people and the work. I want to thank the city council for this honor today. I really do appreciate it. And I have enjoyed working with you. And then to staff, I said it before, CPED will always be close to my heart. They've been my number one client for most of my career. Planners are the best clients a lawyer could ever hope for because they plan before they do. And as a lawyer, that's the best thing there is. And then to my city attorney's office, colleagues and friends, I love you guys. And I'll talk to you individually. I'd prefer to do that rather than sort of give a message here. But this will come as no surprise to the electeds, to staff, to city attorney's office folks. If you want to be here, you will ultimately outlast those with election certificates, and that's just a fact. And it's through those transitions that you forge bonds and you work on challenging things and you achieve good outcomes for the city. And it's those relationships that will sustain you in the long run. And that's what sustained me for 24 years. So stick together and be good to one another. And thank you very much.
Alrighty. I also want the record to reflect that we have Councilmember Wansley and Councilmember Jenkins present. Anybody else? Great. The first item, that's been taken up. Item number 2 is referring to staff and ordinance related to member attendance and reporting requirements for boards and commissions. And item number 3 is postponing to February 25, 2025, the Boulevard ordinance. Members, are there any discussion on both of these items? Councilmember Palmisano.
Thank you, Mr. Chair. Not on both, but I just wanted to briefly mention the postponement of the Boulevard ordinance. We continue to make progress on this, and we want to allow enough time for community meetings to be had and work out some final issues, specifically around permitting. I believe in the importance of expanding the use of our city right-of-way, so do the other authors. I'm thrilled for the opportunity for residents to grow more things in our boulevards. I really value the future of our city's right-of-way space where it can be used for community beautification, stormwater needs, interest in food growing, and other purposes of public good. So we'll get there. We're going to take the time to make sure we do it right. So thank you for considering this postponement one more cycle.
Thank you. Vice Chair Chowdhury.
Thank you, Councilmember Chavez. I think Councilmember Palmisano summed it up pretty well. I'll just make a note to the public and the body. my office is working on pulling together a community meeting, and the fellow authors and then council members who are of interest in joining are welcome to, obviously within the rules of open meeting law. But I think we're making progress in taking another cycle to really clarify to community what this ordinance means and what the current ordinance and code means presently. Presently, our city code doesn't allow for the wonderful plantings and edible gardens that our city really wants to see. And I really hope that community members can understand that the intent is to make it easier for you to do the things that you love to do in the boulevards, especially providing for your neighbors and growing healthy, nutritious food, or beautifying a boulevard with flowers and plantings that you love. So there'll be information on my newsletter and official pages about that community meeting, and just appreciate us taking the time on this one.
Thank you. All right, colleagues, I will move approval of actually item number 1, which is the Eric Nielsen honorary resolution. Item number 2, which is referring to staff and ordinance related to member attendance and reporting requirements for boards and commissions, and postponing the Boulevard ordinance to the February 25th, 2025 meeting. And seeing no further discussion, all those in favor say aye. Aye. Those opposed say nay. Any abstentions? And those items are approved. Next, we will move on to our discussion portion of the committee meeting. First is approving a request to the city auditor for an after-action review of the city and MPD's actions related to the death of Allison Lussier. I'll first pass it on to Councilmember Wansley to introduce that item.
Thank you, Chair Chavez. Allison Lussier was a 47-year-old Indigenous woman who was found dead in her North Loop apartment in February 2024. And since her death, family members, as well as community members and domestic violence advocates have been demanding that officials look into the circumstances surrounding her death, and specifically the role that Minneapolis police played, or the lack thereof, in investigating the details of her death. Data has shown that Indigenous women disproportionately face violence in Minnesota. According to the 2019 Minnesota Missing and Murder Indigenous Women Task Force, despite Indigenous women making up just 1% of the state's population, 9% of all murdered girls and women from 2010 to 2019 were Native American. And community and family members have all shared that Miss Lussier was a victim of domestic violence. And they have raised concerns as to whether actions or inactions taken by the Minneapolis Police Department contributed to her death or have negatively impacted her family's ability to receive the justice that they deserve. Council members are well aware that about a week ago, the Community Commission of Police Oversight took a formal position and requested an after-action related to the city's actions in relation to the circumstances surrounding the death of Allison Lussier, and they requested that this body also approve an after-action review. And that motion was sent to us on January 31st. Calls from the community and Allison's family saying MPD failed them simply cannot be ignored, and we as City Council have the responsibility and opportunity to honor the wishes and requests of Allison's family, as well as the wishes and demands of her community, to enact a thorough and independent after-action review, just as we did several months ago for Davis Maturi, when his life was almost taken by John Sawchak, which was likely motivated through a hate crime. The city's historic pattern and practice of ignoring community accountability is how we've ended up into consent decrees, and Allison's family deserves to know if different actions by MPD or the city could have meant that Allison could be with us today, or that justice for her death could have been served, or could be served even now. If approved today by my colleagues, this after-action review could likely give Allison's family, her community, the public, and this body an independent assessment of those actions, and clarification on what actions we can take and what the Fry administration can take to address any identified problems to make sure that they never happen again. So with that, I conclude, and we'll ask for a second.
There's been a move. Councilmember Wansley has moved approval of this item. Given that there's more than one author, I don't think we need a second. And now if colleagues have any other comments they'd like to make or questions. All right.
No.
So, Vice Chair Chowdhury.
Yeah, thank you, Chair Chavez. I just wanted to take a moment to express my gratitude that we're making this request to the city auditor's office. I think this is just one small thing that we can do as a city body, but I really do want to express my gratitude to every single person that is here in our chambers today, asking for justice, not only for Allison, but for all Indigenous women who go missing and murdered in our city and throughout the state. And I think this is in line with actions that have been signaled by the state level in addressing how we protect Indigenous women in our community and the Indigenous community broadly. And just thank you so much for being here. That's a beautiful picture of Allison that you're holding up. And I hope that her spirit is with us today. And I just send my condolences to the community and the family.
Thank you. I think very proud to support this today and want to thank Jana, Allison's family, for continuously showing up to the streets, demanding transparency, action, and accountability. I think that we know that in this state there is many issues with how our Native community is treated. We know that disproportionately there is missing, murdered, and Indigenous women and girls. We know that the story that we are hearing about isn't just about Allison. It is about our Native community who continuously experiences disparities in not only our city but in our entire state. The Minnesota Missing and Murdered Indigenous Women Task Force found that in any given month from 2012 through 2020, 27 to 54 Indigenous women and girls were actively missing. And I bet you that that's an undercount. That is definitely an undercount. And this is something that continuously happens to our Native community. And I wanted to share those details along with what Councilmember Wansley said, the stark disparities that many of our community members are facing, particularly our Native American community. So I just wanted to make sure that I read those statistics out loud. Seeing no one else on cue, I'll ask the clerk to call the roll on approving item number 4.
Councilmember Payne.
Aye.
Wansley.
Aye.
Rainville.
Aye.
Vita.
Aye.
Ellison.
Aye.
Osman is absent. Cashman.
Aye.
Jenkins.
Aye.
Chugtai.
Aye.
Koski.
Aye.
Palmasano.
Aye.
Vice Chair Chowdhury.
Aye.
And Chair Chavez.
Aye.
There are 12 ayes and 1 absent.
And that was approved. It will go on to full council. Next on the discussion agenda is item number 5, relating to a federal executive action presentation and passage of a resolution authorizing litigation authority to the city attorney. I'll ask the city attorney's office to come up for that presentation and speak to the resolution in detail.
Good afternoon, Chair Chavez and council members. At Councilmember Wansley's request, our office has put together a presentation on federal executive orders and other federal actions that may impact the city or its residents. Just a couple things at the outset. First, there's a lot that we don't know, as I'm sure everybody's seen in the news. There's constantly lawsuits being filed, executive orders and other things being stayed, new executive orders coming out, questions about compliance. So, I mean, this is really an overview of where we are at this point in time. We don't have a lot of answers. And a second piece is, in some of our slides, you're going to see some inflammatory language. That is language from the executive orders. It is certainly not our language. So I'm going to, for the agenda, I have a whole team here that's been working on this and is going to present various pieces. The first piece is just a primer on what an executive order is, then a review of some of the federal spending and funding developments, then a review of some of the key executive orders that impact the city and its residents, and then finally talk about what the city attorney's office is doing in this area. So now I'll turn it over to Harold Melcher to talk about executive orders.
Good afternoon, Chair Chavez, Vice Chair Chowdhury, members of the City Council. My name is Harold Melcher. I'm an Assistant City Attorney in the office. And before we dig into the substance of the executive orders, I would like to sort of just ground us in reality and arm us with facts about what executive orders are, what their limitations are, what we're seeing with these executive orders, and just generally how to think about these executive orders and any future executive orders that we learn about coming up. I think it's important to do that so that we can ground ourselves in reality and start with the facts and then let the facts lead us to our understanding about the executive orders. It will help us to approach them in a more reasonable and balanced and grounded way. So, first and foremost, executive orders are unilateral actions by the President of the United States that generally manage the operations of the executive branch of the federal government. Because the President is the chief executive of the executive branch, executive orders are a way that the President can guide the operations of that branch. They can do a variety of things. This is a non-exhaustive list. For instance, they can delegate executive authority. So the President can tell a cabinet-level secretary or the head of an agency to do X, Y, and Z. They can direct agencies to formulate regulations. They can reorganize executive agencies and their structure and functions to some extent. They carry the force of law, but they're not legislation. And that point sort of requires just a little bit of explanation. We're all familiar with the legislative process. At the federal level, the Senate and the House, they pass a bill and it gets sent to the President and then it's signed and it becomes the law of the land. Executive orders don't go through the legislative process. They go through something called the interagency process, or they generally do, they should. I won't explain to you what that process is. It's not important for our presentation today. But they carry the force of law within the executive branch. So despite the fact that they're, because they're not legislation, they can be revoked or rescinded by a new president. And in fact, we saw that when the Trump administration came in on its very first day. They rescinded 78 Biden executive orders that were operative during that administration. That's fairly common, especially when there is a change in party between one president and another. Like a law, they can be challenged and found to be unconstitutional or illegal. Like a handful of these executive orders have been paused because they've been found to be likely illegal or likely unconstitutional, or there's some other legal problem with them. A couple of my colleagues will discuss a handful of those orders. For instance, one that got a lot of attention very early on was the executive order that purported to end birthright citizenship. That was challenged, I think, the very next day. And someone can correct me if I'm wrong, but I believe that as of yesterday, that particular order has been paused or put on hold in one way or another by 3 federal district court judges. So these executive orders are being challenged and litigated as we speak. One final point, or second to last final point actually, is that executive orders cannot overturn existing law. Only another act of Congress can do that. So an executive order cannot say the president hereby rescinds the Affordable Care Act, for instance. It would take an act of Congress to do that. And the final point general point on executive orders is that these particular orders that we're going to discuss are difficult to analyze. They are quasi-legal, and they are also political positioning statements. They are illustrating the administration's priorities and the actions they want to take. And just because it's stated in an executive order, it's not exactly certain that the authority exists to execute on that executive order. So sometimes that can create a little bit of uncertainty for us attorneys as we are analyzing them, but that's because they are these quasi-legal, quasi-political documents. So at this point, I am going to turn it over to my colleague, Amy Schutt, who will give a brief review of some of the federal spending actions that we've seen in the past weeks.
Welcome.
Good afternoon, Chair Chavez, members of the committee. My name is Amy Schutt. I'm an assistant city attorney. I'm going to talk to you a little bit about the overall impacts on spending and federal funding that have occurred so far as a result of these executive orders. So in the days following his second inauguration, President Trump issued a series of executive orders, which at least in part directed federal staff to reduce or suspend or terminate a variety of federal funding sources. As a result of these orders, the Federal Office of Management and Budget issued a memorandum declaring that it was going to temporarily pause the disbursement of a huge majority of federal financial assistance. This had impacts, widespread impacts on a lot of different funding, including a lot of grant funding that was passed through to state and local government authorities. In response to that OMB memo, several states, including the state of Minnesota, filed lawsuits seeking temporary restraining orders, which would prevent that pause from going into effect. 2 days after that OMB memo was released, the OMB actually backtracked on its memo, rescinded its memo, and said that they weren't going to do the pause. But then the federal administration in different areas of the administration indicated that it might still do a pause. So there was a lot of uncertainty coming from different areas of the federal government about what exactly they were going to do with respect to federal funding. As a result of that uncertainty, federal courts did go ahead and grant temporary restraining orders with respect to that idea of a OMB pause on federal funding. So there are currently temporary restraining orders in place that would prevent OMB from pausing federal funding. That being said, the federal government has indicated it still intends to go back and implement each of the funding restrictions that were listed in the underlying executive orders. There are continuing questions about whether it has the authority to do that or whether that is prohibited also by the temporary restraining order. So we continue to see these developments happening in real time in federal court cases. Regardless of whether these federal restrictions play out now or whether they play out in the future, I think we can view these as a roadmap of what the federal government and the federal administration hopes to implement with respect to federal funding. And with a Republican federal legislative branch, it wouldn't be surprising for us to see the two branches coming together to try to implement some of these restrictions in a more tangible way. And so for that reason, it is important for us to look at each of those restrictions and how they impact the city. And my colleagues are going to touch on those federal funding restrictions as they go through the executive orders with you now.
Welcome.
Thank you so much, Chair Chavez, Vice Chair Chowdhury, members of council. My name is Jocelyn Bremer, and I will be speaking about the Unleashing American Energy executive order. This executive order is intended to reverse years of what the new administration characterizes as, quote-unquote, burdensome and ideologically motivated regulations, which the administration claims have impeded the development of America's energy and natural resources. By implementing new policies and revoking several executive orders from prior administrations, the executive order is intended to promote is intended by the administration to promote and encourage energy exploration and developing by revising the permitting process, revoking or revising existing regulations, and promoting domestic mining, amongst other changes. This executive order sets forth new policies encouraging energy explorations, in reducing regulations on energy production and consumer goods, and eliminating the, quote, electric vehicle EV mandate, unquote. Pursuant to this policy, the executive order also directs agency heads to review, revise, or rescind all existing regulations, orders, guidance, documents, policies, or other agency actions that impose an undue burden on the identification, development, or use of domestic energy resources, particularly oil, natural gas, coal, hydropower, biofuels, critical mineral, and nuclear energy resources, and also directs the Secretary of Energy to restart reviews of liquefied natural gas LNG export projects. The executive order revokes numerous previous executive orders related to environmental regulations under the National Environmental Policy Act, also known as NEPA, and directs agencies to make changes related to consideration and calculation of the greenhouse gas emissions. Finally, the executive order ordered agencies to immediately pause the disbursement of funds appropriated through the Inflation Reduction Act and the Infrastructure Investment and Jobs Act. Guidance issued by the acting director of OMB later clarified that the pause only applied to funds supporting programs, projects, or activities that contravene the policies of the executive order, and that agencies may continue to disperse funds as they deem necessary after consulting with the Office of Management and Budget. But as my colleague mentioned earlier, the funding freeze has been suspended by a temporary restraining orders. I'll pass it on to my colleague, Alex Kane.
Welcome up, Alex.
Good afternoon, Chair Chavez, members of the committee. My name is Alex Kane. I'm an assistant city attorney with the city of Minneapolis. I'll first be talking about the executive order titled Realigning the U.S. Refugee Admissions Program. The practical implication of this executive order is that refugee arrivals will be indefinitely suspended. The policy section of this executive order states that refugees must be able to, quote, fully and appropriately assimilate. This entire executive order has severe implications for families of Minneapolis residents who are attempting to settle in Minneapolis through the U.S. RAP program. According to guidance by the State Department, all previously scheduled travel of refugees to the United States is being canceled and no new travel bookings will be made. Recently, the Sahan Journal reported that Minnesota was slated to receive about 6,500 refugees between October 1st of 2024 and September 30th of 2025. Of those, 1,018 made it to Minnesota by the end of December 2024. And so, based on that information, the rest of the refugees are waiting and do not have any sense of when this EO will be, when the U.S. RAP program will continue to operate. The state has a Refugee Resettlement Programs Office, which is a federally funded office in the Minnesota Department of Human Services that supports the effective resettlement of refugees in Minnesota. The Minneapolis Office of Immigrant and Refugee Affairs doesn't have any contracts or agreements with the state's program, and nor does the Health Department, which were the main two departments we were curious about. So there's no effect there from the funding from the state for that purpose. But one more additional update, or most recent update, is yesterday on February 10th, 3 organizations providing services to refugees as well as 9 individuals jointly filed a lawsuit in federal district court in Washington State state, seeking to declare the executive order illegal and restore all refugee-related funding. So we will keep you updated on how that lawsuit proceeds from here. Next is the executive order titled Protecting the Meaning and Value of American Citizenship. This is the Birthright Citizenship Executive Order. As soon as this executive order was issued, at least 22 states immediately sued the Trump administration. States of Washington, Arizona, Illinois, and Oregon filed emergency motions for temporary restraining orders preventing the enforcement or implementation of the executive order. A federal district judge in Seattle issued a temporary restraining order to halt enforcement and implementation of the executive order, holding, and this is noteworthy, that there's a strong likelihood that plaintiffs will succeed on the merits of their claims that the executive order violates the 14th Amendment and Immigration and Nationality Act. Since then, since then on February 5th, a federal judge in Maryland issued a preliminary injunction indefinitely blocking the executive order, and just yesterday, on February 10th, a federal judge in New Hampshire also issued a preliminary injunction. So this executive order is effectively paused. Next, you will hear from Mr. Bert Osborne.
Welcome up. Sure, they call the old guy Mr. Chair Chavez, Vice Chair Chowdhury, members of the committee, thank you for letting us talk about such a sobering subject today. As lawyers, we look at lawsuits and legal actions probably more than most. I came across a great link in the New York Times from Sunday. You can check it out at your convenience. It's called A Quick Guide to the Lawsuits Against the Trump Orders. And it's a really nice clearinghouse of everything that's out there pending at this point. The two executive orders that I'm going to briefly talk about are called, very dramatically, Securing Our Borders and Protecting the American People Against Invasion. These two orders are just shot through with threats against so-called sanctuary cities, and the threats include denying financial assistance and, of course, threats of removing federal funding. The threats in these two executive orders also include threats to individuals who are here and deemed by the administration to be without sufficient documentation and those who assist them. One of the orders contains a suggestion that the administration will use the U.S. military to enforce the executive orders in American cities, and the orders suggest that that the administration will seek voluntary, air quotes, departures of people it deems to be here illegally. The orders speak about creating a registration list of people without the proper documentation, and there are suggestions in the second order about building large detention camps, and so it's very frightening material in these two executive orders, and I think these two orders will mean a lot to the people of Minneapolis. And all we can do is take the administration at its word when it threatens things like this. Thank you. And I think my colleague Ian is next.
Thanks, Bert. Welcome up, Ian.
Good afternoon. Chair Chavez, Vice Chair Chowdhury, committee members. My name is Ian Spreet. I'm here from the City Attorney's Office to talk about the three executive orders related to DEI, gender identity, and gender-affirming care for minors. The first one, the title is reproduced on the slide in front of you. This is the one that's focused on DEI. It never defines DEI or DEIA or identify who DEI or DEIA programs allegedly harms, but it claims that DEI programs undermine our national unity. And it has, the executive order is full of directives to the federal agencies to end, change, amend their own DEI programs. But as far as language that impacts the city or city residents. It's largely related to federal contracting. Contracts and grant awards must include language that the receiving party does not operate any programs promoting DEI that violate applicable federal anti-discrimination laws. Now, at this point, we do not know what kinds of programs promoting DEI are doing so in a way that violates federal anti-discrimination law. There was an action brought last week in the District of Maryland, asserting that this is unconstitutional, and hopefully that litigation could give us some insight in it, or at least halt to this for some time. But we expect that further litigation and perhaps guidance documents from relevant agencies could clarify what DEI programs violate federal law. At this point, we don't know. Another effect of this executive order is to rescind a prior executive order that required federal contractors to have affirmative action programs. Federal contractors are no longer required to have affirmative action programs. And the executive order also has a section called encouraging the private sector, flagging here that it does say encouraging the private sector. It doesn't change existing law, but it's essentially telling federal administrative agencies how to interpret the law, and it's directing the Attorney General to report to the President how to use existing laws to go after DEI programs. It's essentially asking the AG and other agencies to identify potential compliance actions, or really asking them who can the federal government make an example out of in litigation enforcement actions. Again, that litigation might help us understand what constitutes illegal DEI, but we don't know. And then it has some language in there about making sure schools follow the Supreme Court case from a year or two ago about race-based admissions in college. If there are no questions about that, I'll move on to the executive order defending women, title reproduced up there on the screen as well. This is the one that's focused on sex and gender. A good portion of it is a position statement like we've talked about, but it essentially says there's two sexes, male and female. They're not changeable. The concept of sex does not include the concept of gender identity, and essentially there's no federal support for gender identity, gender ideology, and a lot of the direction in the executive order is to internal federal operations, things like changing, personnel records and forms. Agencies need to, remove statements from their website, that kind of thing. And one of the biggest tangible immediate impacts is with prisons, federal inmates. It's directing prisons to change how they house federal inmates, and there's already been 2 actions brought about that, and temporary restraining orders were issued to stop moving a few inmates around in the federal prison system. But when it comes to directives outside of the federal government and federal operations, it's directing agencies to enforce their laws in keeping with these definitions, which will trickle down to citizens. And in the first instance, like some of the others, and like the other one that I'll discuss, federal funds, agencies are directed to assess grant conditions and grantee preferences to just come into alignment with this executive order. It remains to be seen how that will play out. There is the litigation about the spending freeze, but beyond the money, interpretation of statutes is going to have to fall into line with this executive order. The first one, Title IX, essentially, in Title VII, employment law, gender identity is clearly protected under Supreme Court and case law, but it's not as clear under Title IX, and the order essentially says, it signals to educational programs, colleges, universities, that they are permitted to be restrictive on the basis of gender identity when it comes to sports, bathrooms, locker rooms, facilities, that sort of thing. And then there's this order directs a lot of rule changes and guidance document changes from federal agencies. Housing and Urban Development has a rule about equal access to same-sex emergency shelters. This order has asked that rule be rescinded. The EEOC has guidance documents on harassment in the workplace. That's going to be amended, and the Department of Education has a lot of resource documents to support, protect transgender youth in schools. Those documents have been pulled probably already and are subject to revision. And as far as enforcement goes, they've directed agencies to modify their enforcement efforts in keeping with this executive order, and we don't know also what that looks like yet. I think, for one, we could probably expect that the Equal Employment Opportunity Commission will not be bringing much enforcement litigation in the coming few years on the basis of gender identity. And then the third and final executive order that I have, the title is reproduced there for you, and this is the one that's focused on gender-affirming care for minors. It is essentially stated in this that the policy of the United States is that it will not fund, sponsor, or promote gender-affirming care for minors. And again, the major impact will come through restrictions on research and education grants. Federal agency heads are directed to ensure that institutions receiving grant money are not to provide gender-affirming care for children. And the remainder of the order is essentially directing federal agencies to put your weight behind ending this practice, use the tools in your portfolio. Perhaps the most notable one is Health and Human Services. They're directed to use Medicare and Medicaid by way of conditions of participation, conditions of coverage, to restrict, change, curtail this practice. And then other agencies that might have an immediate effect on citizens, residents, federal employees, their health care plans. This is going to come off of their health care plans. Military members, TRICARE healthcare, this is coming out of their plans. And the DOJ is directed to work with Congress on drafting legislation in that regard. And the final note on this, I'll flag ongoing litigation that was brought just last Friday. The state of Minnesota joined as a plaintiff with the state of Washington and Oregon and a few physicians to allege that this executive order is unconstitutional. That was brought in Maryland, and it seeks restraining orders and declarations, and how that one will proceed remains to be seen. Those are all of my orders. I'll turn it over to Harold. Thank you.
Thank you.
Chair Chavez, council members, Harold Melcher again. We've been speaking for a little while. I just want to take a moment to see if there are any questions for myself or any of my other colleagues before I move on. This is the final executive order that we'll be presenting on.
Thank you. There's no one on queue,
Okay.
and I think it makes sense
Great.
to just wait. Yeah.
All right. So the final executive order goes hand in hand with the orders that my colleague Ian just presented on. The title there, of course, is Keeping Men Out of Women's Sports. That pretty much also sums up the policy that the executive order is putting forward. The policy specifically is that, and I'm going to make sure, I need to go slowly to make sure I say this correctly, that individuals assigned female at birth are the only ones who may play in women's sports, is what the executive order is sort of advocating for. It incorporates the definition of male and female, as Ian presented in the executive orders that he just described to us. It directs the AG to comply with the further rescission of another Biden executive order that, of course, is not in compliance with the spirit and policy within this executive order. The order also says that, just like many others, there will be a rescission of federal funds from institutions that do not have a policy in line with this executive order. And it also directs executive branch staff to convene major athletic organizations to promote policies in line with this order. We've seen this bear fruit for the administration already. Just a day after this order, the NCAA put out or published their own policies that was effectively the same thing as this order. And that is, of course, different than what the Minnesota high school state League, I think Councilmember Chowdhury, you may have said it correctly, I don't think I did, the position that they've taken, which is that the Minnesota State League is required to follow Minnesota state anti-discrimination laws, specifically the Minnesota Human Rights Act, which prohibits discrimination based on gender identity. So that's obviously going to have some implications for athletes here in the state and in Minneapolis, particularly those who are college-level athletes. So with that, I will pass it off to Dan Abelson unless there are any questions on that particular executive order.
Thank you. Welcome up, Dan.
Thank you, Chair Chavez, committee members. Dan Abelson again, and I got the easy parts, the beginning and the end. So I'm going to just talk briefly about what the City Attorney's Office is doing. First, we're continuing to monitor these executive actions as they come in. There's new ones on various topics almost every day. The second is we have sort of multiple immigration teams. First, we have an internal to our office immigration team consisting of attorneys from our client services group, civil litigation, as well as criminal litigation, looking at all the issues surrounding immigration. And then we're also participating in various groups throughout the city enterprise working on questions that are coming up relating to immigration. There's also an enterprise group that our office is participating in on federal funds tracking to really get a good handle on our federal funds, what are the conditions on them, and watching those issues. Finally, we're collaborating with other governments, other cities, states, counties, on these issues where we have a common interest. And then the final piece that the city attorney is going to talk about is the resolution that's before you on participation in front of the court or amicus curiae briefs, and then delegating authority to the city attorney for certain litigation.
Thank you, Chair Chavez, Vice Chair Chowdhury, Kristen Anderson, City Attorney, members of the committee. The resolution before you is a resolution that my office teed up for your decision making. As you can see, we've got lots of lawyers working on a lot of different things related to not only the executive orders but other related federal actions. And we can anticipate that there will be more executive orders and more federal actions as time progresses. So in addition to kind of the internal work that we're doing, the resolution really tees up two different ways in which the attorney's office can represent the city's interests, both our policy interests and our legal interests as it relates to federal actions. One is by submitting amicus curiae briefs, so it's friend of the court briefs. This is something that we are already authorized by the council and the mayor to do under a resolution from 2022, which gives us the authority to submit our participation in amicus opportunities when they align with the city's values and interests. And this is the way that we can represent, again the city's policy interests on matters that end up in court that we're not parties to and that probably we don't have direct legal interests on, but we certainly have policy interests on and want the voice of the city of Minneapolis heard as informational value to courts, and that's in the nature of amicus briefs. We already have signed on to a brief in support of the entities that are challenging the order on birthright citizenship, and we will certainly get other opportunities forthcoming to join other amicus briefs. So the resolution essentially has this body affirming again that you support the city attorney's office joining those amicus briefs. But the second part of the resolution is really to deal with those situations that may arise where the city not only has policy interests in an action at the federal level, but actually has our direct governmental legal interests implicated. Right now, without this resolution, in order for the city attorney's office to bring suit as a party, we have to first come before this body, present the piece of litigation, and get your specific authorization for that specific piece of litigation, which normally works just fine. But we are in a world right now where things move fast and where the implications and the impact on the city may need us to move faster to protect the city's legal interests than would be typical. So let me give you an example that actually wound up not arising, but when we first got the executive order regarding the federal funding freeze, we thought we were going to immediately see the cessation of federal funds. That clearly affects our legal interests directly, and we were, potentially going to need to scramble to get to this body to get authorization to bring suit to protect our legal interests. Of course, that executive order was rescinded, and we have not seen a funding freeze, so that the need did not materialize, but we do anticipate that it could happen. We hope that it doesn't happen, but it could happen that our legal interests are directly negatively affected by federal actions, and we will need to be in a position to file emergency motions for restraining orders or other such things. So what we are asking this body for is the flexibility, the authorization, sort of a blanket authorization from my office that when we determine that it's necessary to do so to protect our legal interests, that we are able to quickly move to file that litigation without first having to come before this body. It's obviously really important, though, that you all have information about what your attorneys are doing. So the resolution also provides that when we decide to file actions, we will have oral communications so you know what's going on. And then at the very next regularly scheduled council meeting, we would come before the body and likely in closed session and talk about what litigation has been filed. We put a sunset date on the resolution, so sunsetting at the first council meeting in the 2026 term, so that we can sort of see how it goes, and the council can be in a position of either renewing or not renewing. And again, this is a protective action. It may be that we will not have our legal interests directly impacted, and we won't have a need to file direct litigation, but if we do, we might be in a position of needing to move quickly. So that's the reason for the resolution.
Thank you. I appreciate the update. Colleagues, anybody on queue? Council President Payne.
Thank you, Chair Chavez. I just wanted to thank the City Attorney and the City Attorney's Office for being so proactive on this. This is a very chaotic time in our country, and I think one of the things that gives me confidence here at the local level is just our commitment and dedication to the values that we all share, and I think this is a representation of that. So looking forward to supporting this action.
Councilmember Wansley.
Thank you, Chair Chavez. Also, I want to echo gratitude for our city attorneys in both putting together these updates for today and also doing the briefings with council members to get a little bit more in-depth into particular questions that council members had about, specific impacts that might be going on and related to ordinances that they're working on or just constituent issues too. So I want to say thank you, and also to Vice Chair Chowdhury, who also made sure to incorporate our intergovernment relations staff into those meetings, because we know there is interconnectedness there too. But I did have a couple follow-up questions on some of the slides, specifically the RAP program. I don't recall what numerically where the slides kind of fell into, but the RAP lawsuit, you did mention there was a lawsuit that was
filed, I did want to know the likelihood of a TRO being issued in the case of that one.
Chair Chavez, Vice Chair Chowdhury, Councilmember Wansley. I do not know the answer to that question. I don't know how likely a TRO is being issued. I actually haven't read the complaint, so what I can do is read the complaint and see if they're seeking TRO and get back to you on that, back to your office. But it's hard to assess, even if they are, it's hard to assess the likelihood because this is the first one. We haven't seen another interpretation of this executive order yet. So I'm happy to read that complaint and then get back to you.
Okay, I'll just note that for a staff follow-up in terms of just follow-up on the RAP and the complaint that was filed on that particular executive order.
Absolutely.
And then following on to next slide related to DEI. Also just clarification on this. Since you mentioned in the executive order, there wasn't any actual explicit definitions given in terms of what DEI or DEIA consisted of. And yet we saw a lot of businesses and corporations abandoning programs. And I had assumed that was the baseline of fear of not losing funding. I mean, we saw that even here with Target getting rid of their own program. So I'm confused. We haven't done the same here. So is there somewhere where I guess I'm a little confused in terms of why there was such a hurried response of different public and private business and organizations that decided to offload their DEI program citing legal risk if there wasn't any legal definition for what this actually consists of in the executive order.
Sure. Chair Chavez, council member. My suspicion is that comes down to the risk tolerance of a given organization. I without a definition of, although certain terms, DEI, DEIA were not defined in there, I think there's a general understanding of what sorts of programs, mandates, affirmative action sorts of programs constitute DEI, and I think what you're probably seeing is the pendulum swinging and risk tolerance of a given organization deciding to go in the direction that the wind is blowing when it comes to these executive orders and that executive order. So, but that may or may not have been a strictly legal determination by that organization or by an organization.
And I mean, I'm guessing, can these different businesses, are they able to join on to any of like these lawsuits that like certain states are filing on? I don't know, like in terms of amicus, where it's just to beef them up to say like we support these legal challenges in terms of declaring them to also be unlawful, both morally and legally?
I'm sure at some point there's the current DEI litigation that's in Maryland was brought by 2 or 3 interest groups. I think it's the National Association of Diversity Officers in Higher Education. I think 2 or 3 other interest groups, and the mayor and city council of Baltimore. So it is a diverse coalition of plaintiffs that are bringing that case. As far as other plaintiffs joining or other parties filing amicus briefs, there may be a point in time that they're able to do that. I think at this stage, the court is probably just evaluating the temporary restraining order that was brought, and that hasn't been ruled on yet.
Okay, and then you also spoke on the gender-related executive order or the sex. Yes. You mentioned that the Equal Opportunity Commission would not be making any or bringing any legal challenges. I wanted to get a little bit more information as to why that was not happening.
It seems unlikely to me, council member. There is a commissioner, a body, maybe 5, I think it's 5 commissioners at the head of the EEOC, and 3 of them were removed. I think they're down to 1 or 2, and the chair, the acting chair, the acting commissioner, I can't recall the exact title, is Commissioner Lucas, and her public statements indicate that, she is on board with the directives of this executive order, and though gender identity is protected under the law, I think it's probably fair to assume that the EEOC is not going to be putting a lot of effort behind in enforcing anti-discrimination laws on gender identity grounds.
Okay, that makes a lot of sense then, unfortunately. That's all the questions I had. Just a brief comment too. I think this was the first slide related to the funding or federal funding freezes, and also seeing last night too that I think I forget which court found that Trump administration wasn't following the temporary order, which you called out. And I know in particular one of those relating to, I think, the National Institute of Health funding, in terms of the cuts that they're relaying for their departments, that I know is going to also impact specifically universities, like the University of Minnesota, and what that means for the funding landscape of that university. And as we're going into the legislative cycle, where we're always talking about just the precarious nature of like what funding is looking like. So it's interesting to hear about that cap and how they're still looking at slashing funding and pursuing that, and then what that means even for universities here and how they're going to be going to the Capitol in light of that, and what that means for like support here. So I'm sure, again, Councilmember Chowdhury are going to be busy, which it seems like you already are at the Capitol. But yeah, it was just unfortunate to hear that, which I'm not surprised. Like, he really does not seem to be really a follower of law. But yes, that's all the questions and comments I had.
Thank you. Thank you. No one else is on queue. Just want to thank the City Attorney's Office and all the staff today that came and gave us this presentation. It was very thorough, very helpful, and I think it's going to be very helpful for our residents to just be able to understand what the meaning of these executive orders are. So I'll move approval of this item. And seeing no further discussion, I'll ask the clerk to take the roll on item number 5, which is the passage of a resolution authorizing litigation authority to the City Attorney's Office.
Councilmember Payne.
Aye.
Wansley.
Aye.
Rainville.
Aye.
Vita. Aye. Ellison.
Aye.
Osman is absent. Cashman.
Aye.
Jenkins.
Aye.
Chuktai.
Aye.
Koski. Aye. Palmisano. Aye. Vice Chair Chowdhury. Aye. And Chair Chavez.
Aye.
There are 12 ayes.
And that carries. Thank you so much. Items number 6 and 7 are part of the settlement agreement and consent decree oversight subcommittee. So I will turn the meeting over to President Payne as chair of that committee.
Thank you, Councilmember Chavez. Since items 6 and 7 are related, we'll take them up together. Both of these items are authorizing contract amendments with Storm Training Group for services related to training both police department officers and police department academy recruits. This is for use of force training and de-escalation training in alignment with the settlement agreement. I see Commander Brown is in the audience if members have any questions. Councilmember Wansley.
Oh, sorry, Council President Payne. This will be after these items are taken up.
Got it. Any other questions on these items? Councilmember Cashman.
Thank you. I was just wondering what the difference is between these two items. I couldn't find it really written here in the brief description.
I believe one of the contracts is for existing officers and the other contract is for recruits, if I got that correct.
Okay, thank you.
Councilmember Rainville.
Thank you. Commander Brown, just a quick question. How's it going with this new intensive training? How do you feel about Storm? Are they fulfilling your expectations?
Yes, sir. Commander?
Council President, Council, thank you for this opportunity. Council Member Rainville, we're very pleased with the contracted vendor for arrest and control, which is Storm. So Storm has been, we've been utilizing, when we had staffing, we were utilizing the techniques that are taught by Storm, and is basically a research-based application of use of force, or de-escalation is a probably better way to put it. We've been utilizing that techniques for prior to contracting with Storm. So Storm was the certified one. When we lost our staffing and haven't been able to fulfill that yet, with that, we've started contracting directly with Storm to provide that training. So we've been more than pleased with it, and it definitely has been it's instrumental in continuing to train the officers effectively in those techniques. And so thank you.
Thank you. Just so to dwell on what you said, we have to farm this out to a vendor because we don't have the staff to do training in-house?
Councilmember Rainville, yes, sir.
Thank you.
Councilmember Chowdhury.
Thank you, President Payne. Thank you, Lieutenant Brown. This is a question for you. I just was curious how many police officers were expected to go through this training this year and into March. Do you have a number? Is it our entire sworn force? Yeah, just curious.
Council President Payne and Councilmember Chowdhury, yes. Specifically, the whole department will be going through training that's taught by Storm. Storm will be conducting all the in-service training. So the settlement agreement training that we're doing is a 3-day training that starts in April and will go until the second week of August. So it's broken up. So the whole entire department will be going through that. That's for the in-service portion of the training. As for the pre-service, so that's the continuing education, and the pre-service, which is our police academy, that training, they are instrumental in training both of our brand new officers who are coming in who have no prior law enforcement experience, but also they'll be training in all of our lateral officers that come from other agencies to make sure that they implement our policies when they're working in our agency. So,
when is pre-service set to begin?
Right now, ma'am.
Right now?
Yes,
Okay.
ma'am. We do not have any pause between our. Did you say in-service or pre-service?
Pre-service.
Yeah, pre-service. So we had an academy that, a lateral academy, we call them orientations. That's basically, we have them scheduled with that Storm. So you'll see on the Storm contract, they have a price point of saying this is how much it could cost, but it could cost as much as this cost. And the reason why that is we break up the cost of each individual lateral course, and we have scheduled to be able to facilitate a lateral orientation, so an academy for pre-existing officers that we bring over with the police law enforcement experience. We have one scheduled for every month as we have candidates. So as we can bring in on board and background new officers coming with experience, we will train them in. And but when we don't have them, we don't have staff standing around. We just don't pay that portion of the contract. So so we do have lateral courses scheduled for every month, and then we have 3 scheduled training academies for anybody that doesn't have prior law enforcement experience. That's for February, June, and October for the general academies, and laterals, like I said, every month.
Great. Thank you so much.
Yes, ma'am.
Any other discussion? Seeing no one else in queue, I will move approval of both items 6 and 7. All those in favor say aye.
Aye.
Opposed say nay. The ayes have it, and I will return the chair back to Councilmember Chavez.
Thank you, President Payne. Next, we will receive reports from standing committees on matters to be considered by the full council this Thursday. We'll begin with the Administration and Enterprise Oversight Committee, chaired by Councilmember Wansley.
Thank you, Chair Chavez. But prior to that, I think Council President Payne forgot I had a matter raised related for the Settlement Agreement Committee or Subcommittee. Yeah.
Go ahead.
Thank you. Actually, this is for the CAO, Kristen Anderson. I know we had conversations about this, but I wanted to get a sense of if you could share an update on when we can anticipate the next update related to the DOJ, especially in light of the previous presentation. I had actually anticipated a brief update to be incorporated with that presentation, because that also was part of the executive orders in terms of a freeze within the DOJ for civil litigation. So is there, a time in which council can expect to get an update on those proceedings?
City Attorney Anderson.
Councilman Member Wansley, and I'm happy to give a really short update right now, if that's okay with the body. So interestingly, that memo, the DOJ memo, was extremely ambiguous about what sort of the position of the DOJ might be on filed litigation. It certainly told the DOJ to stand down on anything sort of in the pipeline, but was really not clear, to me at least, on exactly what the directive is about filed litigation. So as you all know, we jointly with the Department of Justice filed a motion in federal court to accept the consent decree. Unless and until the DOJ does something formally in federal court, that motion is still, again, a joint motion and pending before the federal district court judge. We anticipated that the judge would need some time to review the materials. It is obviously a very long, complicated consent decree. So we are just sort of in a holding pattern, waiting for the judge to reach out to us to schedule a briefing and court date.
Thank you. And just a quick follow-up on there. Is there just an ultimate deadline in which the judge has in order to make a decision?
Council member, no. Federal court judges are very much in control of their own calendar, so he's not bound by any particular time frame.
Okay. It's good to know. I know in other conversations, it seemed like there was at least some type of concentrated timeline in terms of a couple, 60 days or so. So this is good to know. All right. Thank you.
And maybe, council member, it's sort of what I anticipate versus what the court is actually required to follow are two different things.
Yes. Can you provide clarification on the required? Yes.
Yeah. So the court does not have any, there's no requirements in the rules about how fast a court needs to respond to a joint motion like this. So it's really, up to the judge and his timeline.
Okay. So they can take as long as they want, indefinitely to the end of the year, to next year,
Council member, truly there's no deadline, but it would be very unusual for a district court to just sit on something indefinitely. So, I would anticipate, within the next month or two to be hearing from the court, but I can't promise it because it's not actually, in the rules that it's required. So.
Thank you for that brief update. I know a number of us have been getting questions in terms of concerns around hearing, again, the executive order around the DOJ's also freezing of civil litigation and what that meant for our own consent decree. And I know, again, having conversations with you about what are some of our options in case the worst happens. So definitely will be continuing to pursue that with you all, with the CAO and with my colleagues to make sure that, we can guarantee compliance and implementation of the DOJ consent decree at any cost. So thank you for that brief update.
Awesome. So next we will receive reports from standing committees on matters to be considered by the full council this Thursday. Councilor Wansley, if you can give the update on the Administration and Enterprise Oversight Committee.
Yeah, back to back. Here we go. All right. So the Administration and Enterprise Oversight Committee is bringing forward 16 items for consideration. The first is a gift acceptance from Metropolitan Police Department of Travel and Lodging. And then the second is a gift acceptance from the New Jersey Environmental Health Association of Registration. And then the third is a gift acceptance from Hello Heart of Travel travel, lodging, and meals. Number 4 is a bid for Bridge 9, Ward 2 Ped Bike Bridge over the Mississippi improvements. Number 5 is contract amendments with senior services providers. 6 is a contract amendment with Cornerstone Advocacy Service for sexual assault case advocacy services. 7 is contract amendment with House Brokerage Inc. for hauling and disposal of agricultural liming materials. 8 is contract amendment with Family Tree Clinic for sexual health services for youth. 9 is contract with Advocates for Better Health as fiscal agent for Minneapolis Health Department's Public Health Community Institute. And 10 is legal settlement with Mohammed Shahidullah, City of Minneapolis. 11 is joint powers agreement for embedded social worker in Minneapolis Emergency Communications Center. 12 is legal settlement workers' compensation claim of Ricardo Muro. 13 is a legal settlement workers' compensation claim of Jonathan Patron. 14 is a legal settlement workers' compensation claim of Michael Griffin. 15 is a legal settlement workers' compensation claim of Luis Perez. And then 16 is a legislative directive looking at the fire department recruitment landscape. So with that, I'll stand for any questions.
Thank you. Next up, we have the Budget Committee, so I'll pass it on to Vice President Chuck Tai.
Thank you, Chair Chavez. The Budget Committee will be bringing 4 items to Thursday's council meeting. Item number 1 is approving an appointment to the Capital Long Range Improvement Committee for seat 6. Item number 2 is passage of resolution for the City Hall project for AV broadcast and captioning equipment for the council chambers. Item number 3 is passage of a resolution moving funds to the Minneapolis Emergency Communications Center, or 911, to support the joint powers agreement for an embedded social worker. And finally, item number 4 is considering a resolution approving violence prevention funding for Hennepin County. This item was forwarded without recommendation. With that, I will stand for any questions.
Thank you. Next up, we have the Business, Housing, and Zoning Committee, so I'll pass it to the Vice Chair of that committee, Councilmember Ellison.
Thank you, Mr. Chair. The Biz Committee will be bringing forward 12 items Thursday's council meeting. 1 is a liquor license application for Bar Harmony. It was forwarded without recommendation, but hoping that Councilmember Rainville is sorted things out with the business by the time we get to Thursday. 2 is approving a rental hall and extended hours license for the 1893 at the historic Grain Belt office. 3 is granting an appeal to Richard Hutzell for demolition of the property located at 3120 Washburn Avenue. 4 is granting an appeal to Craig Harris for a certificate of appropriateness for the property at 204 5th Avenue Southeast. 5 is approving the liquor license application. 6 is approving the liquor license renewals. 7 is approving a rental license reinstatement. 8 is approving 17 business district revitalization grant agreements. 18 is approving a neighborhood revitalization program forgiveness loan to Mercado Central. 10 is approving additional 2025 housing tax credits for the housing project at 2116 Nicollet Avenue South. 11 is a passage of a resolution approving hate crime prevention guidelines. And lastly, we have extended hours license for Lowry Handy Stop. This item was sent was forwarded without recommendation. I hope that everybody's been able to read the attorney's memo on this item, and that we can get that application approved at full council as well. So that's all. Stand for questions.
Thank you. We have Council President Payne on cue.
Thank you, Chair Chavez, and thank you, Councilmember Ellison, for your leadership on this, and Councilmember Cashman for jumping in to support. I've since had an opportunity to speak to the owner of the Handy Stop, speak with the precinct inspector, and I'm working with the city attorneys to potentially refine what we were trying to consider. I think part of this was perhaps an inadequate level of communication or maybe a miscommunication around how our business licensing staff is going to be engaged with this business from now until May. They are going to have some heightened engagement around ensuring that there aren't any incidents that would necessitate security. But there was some discrepancies between some of the data that the constituents requested with some of the guidance that we got initially. And so I'm just having our city attorneys review that, and perhaps there might be some refinement here, or at least I've gotten some reassurances from staff about how they're going to be engaged with this license between now and May, when it would be up for renewal. So if there were incidents that were to happen between now and May, there might be some heightened need for security. But I'm still going to be working through those details between now and Thursday, and stay tuned.
Alrighty, no one else is on queue. So next up, we're going on to the Climate and Infrastructure Committee, and I'll pass it to the chair, Council Member Cashman.
Thank you, Chair Chavez. The Climate and Infrastructure Committee is bringing forward 8 items to Thursday's council meeting. First is passage of ordinance for the gas franchise agreement. Second is the passage of an ordinance for the electric franchise agreement. 3 is the MOUs with both CenterPoint Energy and Xcel Energy for the Clean Energy Partnership. 4 is authorizing a subordinate funding agreement with the Metropolitan Council related to professional staff costs on the Blue Line Light Rail Extension project. 5 is authorizing acquisition of a permanent utility easement related to the Upper Harbor Terminal public infrastructure. 6 is authorizing the submittal of a grant application to apply for the Municipal Investment Fund Planning Grant for geothermal planning. 7 is directing staff to conduct a landscape review of policies designed to support property owners on expenses related to lateral water and sewer lines. 8 is directing staff to research and analyze nationwide special assessment assistant programs. And lastly, George Floyd Square concept layout was referred to the city clerk to be placed on file for further consideration. I'll save for all questions and comments, but I just want to give a comment on the number 9. So last week in the Climate Infrastructure Committee, we voted to refer the 38th in Chicago concept layout to the clerks. This action builds upon the council passing a resolution on December 5th of last year supporting the pedestrian plaza concept plan. This action from last week puts the open, flexible concept layout on pause and ensures that the entire work done to date on that plan is not lost. And then with that, I'll be walking on a legislative directive this Thursday, asking the administration and Public Works to come back with findings of fact related to the pedestrian plaza concept layout per the requirements of the new state statute guiding this. This will allow Public Works to pursue the pedestrian plaza concept in compliance with the statute without losing the work on the flexible open concept that they have done. The legislative directive has been worked on in consultation with and with input from the Office of the City Clerk, City Attorney's Office, and the Department of Public Works leadership. I received draft copies of this, as well as a Public Works timeline for all of the work that they plan to do in the coming months to my email during this meeting. So I will be sharing that with all of you and the clerks by the end of today. Thank you.
Thank you, Councilmember Koski.
Thank you, Chair Chavez. Colleagues, as you're aware, the chair just talked about, there's going to be a motion to forward to the clerks the recommended concept layout for George Floyd Square. And the motion essentially puts this on hold or on pause of that concept layout while the committee explores a pedestrian mall ordinance. That motion received a majority of vote in committee, and it is poised to receive a majority vote at the council. So to that end, I'll be walking on a legislative directive asking the administration to develop a proposal for piloting pedestrian plaza and mall models in the interim to demonstrate these models to business owners, neighbors, local organizations, and the community at large so they can experience them before making a final decision on the potential pedestrian mall ordinance. The administration is currently reviewing the said legislative directive, and after conferring with the administration, I will share the final draft of that legislative directive with the City Council and clerks likely later this evening. Thank you.
Thank you, Councilmember Jenkins.
Thank you, Chair Chavez. I have a number of questions related to the last two comments and/or number 9 action. I guess I'm going to ask Councilmember Cashman, can you explain to the community why you feel this is important to delay this process? And then subsequently, the question for Councilmember Koski, the pilot program, would that come after reconstruction? I'm not sure how you pilot a pedestrian mall. Can you share more information about that?
For sure.
So first, I want to hear from Councilmember Cashman, and then secondly from Councilmember Koski.
Yep.
Thank you, Mr. Chair.
Thank you, Councilmember Jenkins. And what I'll just ask colleagues is that these are going to be walk-ons. I hope that there's conversations with you about those walk-ons, because this is not on the agenda right now. So I would like to strictly keep it on the conversation about the ICE, the motion that was taken at climate infrastructure.
Well, my question to Councilmember Cashman is directly related to number 9.
For sure, and that's what I was going to say. But I just want to make sure that we can answer those questions, and then I just hope that the authors of those directives just talk to Councilmember Jenkins ahead of Thursday. Any other colleagues have questions? But if people want to stay here long, I'm happy to entertain those conversations.
Okay, thank you, Chair, and thank you, Councilmember Jenkins. I really appreciate all the work that Public Works has put into the infrastructure project at 38th in Chicago, as well as the work that the CPED department has put into the RFP for the People's Way, which is ongoing right now. The organizations that applied are going through a process of community engagement, and then we're all going to have the chance to review and weigh in on the future of the People's Way this spring. So that work is ongoing. I'm also really appreciative of the Arts and Cultural Affairs Department memorializing the public art in this space. As far as the infrastructure piece, the Public Works infrastructure piece, when the open flexible concept came before the Climate and Infrastructure Committee, it was really unclear to me and a lot of other folks what the pedestrian component of it was. They did say it's possible to do pedestrianization of this space in the future with gates, with detours, with closures of the street for events. But the details on how that would be implemented were not laid out for us, as in where would the detour go? Where would the gates be placed? How often would the street be closed so that pedestrians can gather? So I think that, we deserve as a council and as a community to have a pedestrian component, a strong pedestrian component to this plan so that people can gather and memorialize George Floyd at this square for generations to come. This is going to be a 50 to 70 year plan, and we only have one shot to do it right. And I really believe that the pedestrian piece needs to be front and center for the community in this space. So that's why we have found a way with Public Works for them to explore the findings that they need to comply with state statute and bring a design that would be legally permissible, that would allow for pedestrianization of some form to occur here.
Legally permissible requires 51% of all the owners to be in agreement, which does not exist.
Yeah, thank you for that question. I'm a little frustrated that the mayor chose to put out that information when we were very, very clear.
It's true.
That, no, excuse me.
Who you didn't think was the hundreds of city residents.
Councilor Jenkins, the question.
Who you didn't think was hundreds of city residents who have contributed to this plan.
I just wanted to be clear that the pedestrian portion that we're asking for
and
is
which
only
they said,
the part of...
we don't want a
Councilor
pedestrian.
Jenkins, did you ask the question of Councilor Cashman? Councilor Cashman is trying to answer that question. Councilor Cashman, please proceed with answering the question.
We are in conversation, sir.
And this is committee. You asked the question. Councilor Cashman is trying to answer that question. Councilor Cashman, please proceed with answering the question.
The part of the square that would be pedestrianized only goes to the northern end of the People's Way property. From 38th to the northern end of the People's Way property. So there's only 2 property owners implicated. One is Unity Foods, and one is the city of Minneapolis.
Councilmember Jenkins, do you have any more questions? But otherwise, we can continue this conversation at full council, where there's going to be this conversation happening anyways.
Sure, fine.
Cool.
It's your committee.
You're still on cue. Should I?
Do whatever you want to do, sir.
I'm trying to be respectful here. Okay, cool. All right, colleagues. Next up, we have the Public Health and Safety Committee. I'll pass it to the Vice Chair of that committee, Councilmember Wansley.
Thank you, Chair Chavez. The Public Health and Safety Committee is bringing forward 7 items to Thursday's council meeting. The first is a passage of resolution accepting additional grant funds from the Minnesota Department of Health for the Public Health Response Sustainability Grants. Number 2 is authorizing a memorandum of understanding between the Department of Veteran Affairs and the Police Department for intra-agency coordination. 3 is authorizing a memorandum of understanding between Augsburg University and the Police Department. Number 4 is authorizing a contract with Minnesota Recovery Connection to implement the Public Health Regenerative Leadership Synergy, also known as Fearless, grant. Number 5 is a passage of resolution authorizing and accepting a contract with City Match for the work. There's a typo on here. City Match for the work on the Healthy Families Community-Based Prenatal Health Initiative. Number 6 is directing staff to research autonomous food delivery technology and its impact on workers. And then 7 is legislative directive related to information about the administration's 2025 summer safety plan. And with that, I will stand for any questions.
Thank you. No one is on cue. So, members, with that, we've concluded all business to come before committee today, and hearing no objection, I will declare this meeting adjourned.
So, Katie, what are you talking about?